Welcome to Euractiv's Tech Brief podcast. My name is Luca Bertuzzi, your technology editor. This week, we take a global perspective on data protection. For an overview on all technology in the EU, sign up to our free newsletter or visit the website euractiv.com. This is Euractiv's Tech Brief podcast. Today, I'm joined by Gabriela Zanfir-Fortuna, Vice President for Global Privacy at the Future of Privacy Forum, and Rafi Azim-Khan, Head of Data Privacy at Pillsbury Law. Hello, both.
Hello.
Hi there.
Great having you here. So, Rafi, let's start with you. The idea is really to give a global perspective on data protection and the trends that we are seeing. And I think the starting point would be the EU's immediate neighbor, the UK. There have been discussions about a new data protection regime in the UK for quite some time, and now we are seeing a bill finally moving ahead in Parliament. So what are the key features of this legislative proposal?
It's a very interesting time to have this conversation because I think we're genuinely at a kind of crossroads of some countries wanting to take more of a unilateral approach to data laws and in their eyes, freeing up some of the red tape or regulation. But that comes at a potential cost as more and more businesses are multinational, international, and the web is obviously global in reach. And there is this desire to have more uniformity and international consistency. And what's very interesting is that the UK has been looking to make some changes to the GDPR and effectively the Data Protection Act that we have in the UK, which post-Brexit effectively transposed over pretty much a mirror image of the EU GDPR. So one of the really tricky aspects of this is to see how one can juggle these two potentially competing interests. I thought it was very, very interesting. We were asked to contribute to some consultation discussions, and I actually attended a number of meetings myself with a number of the government team that were working on some of these proposals, including some of the visiting delegation from the US Department of Commerce and other US government teams who were looking at both what changes might come about vis-a-vis a rebooting of Privacy Shield, for example, which of course was shot down post Schrems 2, and which we've now seen with the Biden executive order coming along and promoting the new framework, the DPF. And at the same time, the UK government, through its Secretary of State, making announcements that they've been listening to complaints from UK businesses, in some cases wanting to get their red tape requirements, as they saw it, more aligned with an approach that would be something that the US would like, but might be one or two steps removed from what the EU would like. And so you had this juggling of different competing interests, which culminated in this DPDI2, as it's known. So the new reboot of the legislation, looking at the data protection laws. And we've ended up with a very interesting sort of shopping list of things which are being promised that will be changed, which is now in the draft and going through Parliament. And in a nutshell, if you actually look at what the UK Secretary of State, Michelle Donnellan, was saying, she was basically sort of framing it as we're going to have an approach which will help businesses and citizens untangle themselves, as she put it, from again, what she described as a barrier-based European GDPR. And the new laws, in their eyes, will be something which will be easier to understand and easier to comply with. In very brief summary, I think there's some very interesting things in the proposed changes. So there are some changes around legitimate interests. There are some changes around some of the risk assessments that controllers are supposed to consider. There's some changes around records of processing activities, also some changes around DPOs, data protection officers, And very interestingly, some loosening up of the international data transfer rules that business has to consider, which is particularly topical because of all the proposals coming out of the US, as well as some of these international initiatives. And I think even on some of the more granular levels, so on the slightly smaller levels, even if you think about some of the changes, which might not sound overly dramatic. So, for example, some changes to remove certain consent requirements for cookie use, for example, by way of an expanded range of exempted purposes. That just on its own does seem to be running counter with recent heightened enforcement in Europe. So, for example, the CNIL fines and activity in the last year or two over enforcement of the e-privacy directive regarding cookie use, and some of those big fines that were being levied on companies such as Google. So you have this very interesting thing going on right now, which is the UK wanting to be seen to be pro-business, low red tape, pushing itself into that kind of a position, which is sort of leaving it at odds to a degree with Europe in its efforts to try and free things up and get closer to the US. And of course, final comment I'll just make in summary is the point about adequacy is a really key point, which is obviously post-Brexit, there was a real concern over what might happen with transfers between the UK and mainland Europe. And the adequacy decision did take a little bit of time, and people were a little bit nervous waiting for the EU to grant the UK adequacy status. But when it did come, it came with a few caveats, because clearly some on the European side are watching the UK quite closely. And there was a concern that the UK might indeed go off on a bit of a frolic, which would, in their eyes, mean they weren't indeed going along with this sort of the GDPR approach. And the adequacy decision that was given for the UK obviously came with a sunset review timescale to it, which was unique. It hadn't been done before. And so I think there is a genuine concern that depending on where the UK reforms end up, query whether that might lead to a potential issue in terms of adequacy being removed. So I'll pause at that point. But I do think very interesting times with all these proposed changes.
Thanks, Rafi. Quite a few things to unpack there. I would say let's start with the United States, which you have mentioned as well. Gabriela, there have been talks for some time about the US trying to put in place a data flow system that is alternative to the EU data adequacy decision. I'm of course referring in particular to the global cross-border privacy rules forum. How is that initiative going? Do you think that it has managed to gain momentum, or has it fallen into obscurity, I would say?
Indeed, the U.S. Department of Commerce has been revamping an older initiative that was particularly applicable in Southeast Asia, in APAC, in the APAC countries. And that's the APAC CBPR system. Cross-border privacy rules system. And that has been in place already for many years. And that has not been extremely successful if we are looking at how many companies participate in it. Now, in the past year and a bit, the U.S. Department of Commerce has started to rethink that CBPR, APAC CBPR system, and wanted to give it a global scope. This means that it would allow countries that are outside of the APAC system, and that countries such as the UK could join, but not only. The invitation is actually open to the entire world at this point. The initiative is gaining momentum. As we've seen very recently, the UK has joined the Global CBPR Forum, and to my knowledge, it's the first country outside APEC that actually has joined. So there is something there. Now, the question is, will the Global CBPR Forum be more successful than the APEC CBPR system? We don't know yet. The judge is still out there because we need to see how many companies will actually certify, how many accountability agents will want to become accountability agents in order to participate in the system and help with the certification process. So that's still out there, but there is definitely interest from countries outside of APEC to join this, and we shall see. Now, one thing that I want to make very clear is that generally the idea of certification as a mechanism for transferring personal data across border is not new, right? It has been around for a while. And in fact, it has been recognized also by the GDPR. Like, certification is one of the current possibilities to transfer personal data. It's one of the alternatives when there is no adequacy in place. So the way I'm looking at this development is that, it's another tool in the transfer toolbox, and it might be, very helpful for many jurisdictions and many companies that transfer data outside of the EU. However, when we are talking about transferring data from the EU and under the GDPR, of course, the systems would need to be compatible, right? So that's another sort of assessment that needs to be done.
Thank you, Gabriela. And it's also quite interesting to see these very different approaches from the US more open door approach and the EU, which is more basically saying you either keep up with our standards or you don't qualify. But I would like to go back to the UK with Rafi now, because indeed, as you mentioned, the UK wants to move closer with its data protection regime to the US. In particular, the government said that its approach is inspired by the Californian data protection law. But at the same time, the EU GDPR has been the inspiration for several data protections laws worldwide, including in some US states. So, turning the question around of what Gabriela raised, it really depends on how successful this alternative standard for data protection is. But doesn't that also mean that the UK risks to become internationally isolated in case things go south?
Yeah, I think that's it's a really good observation. It's a good point. It's worth considering for a moment. I think the way I kind of look at it is, if you see what effectively historically has been happening, and then we look at these recent developments, I think it's quite interesting. So we had the original dot-com boom period, and businesses were sort of embracing e-commerce as a concept, the web as a concept, monetization of digital revenue and digital business, the ability to interact with people all over the world. And suddenly you had this global marketplace. And one of the concerns which really drove a lot of the EU laws was indeed this perception that the US was a bit of a Wild West, and that there weren't any real comprehensive laws that applied. And that obviously drove various things. So we had the first data protection directive, we had the e-commerce directive, digital signatures directive, distance selling directive, and so on. And then if you fast forward a few years to more recent times, we obviously then had GDPR come along, because again, there was this concern that a number of the very big Silicon Valley companies and other US digital major corporates were, being used by many citizens all over the world, and there was this concern that there wasn't enough specific, up-to-date legislation. So we had GDPR. So Europe really has a history of wanting to take the lead and wanting to be quite prescriptive in relation to laws that it thinks are missing. And I think what we're seeing now is we're seeing two things all at the same time, really. And they're not necessarily consistent. So you have GDPR, which since GDPR came into force, you've had a ripple effect, a genuine ripple effect around the world. And this also includes the US. So GDPR began to influence laws in various countries. So Brazil, for example, with its new data laws, various other countries as well have been leaning towards this GDPR model. And the US initially, obviously the US does not have there's been various proposals spoken about and so on, but there isn't a current federal-wide US equivalent of GDPR. So we had California come along with CCPA, and California initially went with some degree of influence from GDPR, but also quite a lot of differences. So the CCPA is quite different in a number of respects, even though there are some similarities. It is quite different from GDPR. And what was interesting is as the US was developing, additional states were obviously putting their proposals through. And if we just look at what's been happening in the last year or two in the States, you have a number of additional states now passing their own forms of privacy laws. So you have Utah, for example, you have Colorado, you have Virginia, you have Connecticut, and lots of other proposals as well. And of course, in Washington State, a number of tech companies up in Washington State, obviously, it's an important state from that perspective. They had a number of their own proposals for their Privacy Act. And what I think is really interesting is the approach taken by the most recent new US laws, so Connecticut, Utah, etc. That actually didn't directly model, they didn't model themselves on the CCPA California approach. What they actually did is they actually modeled themselves more closely on the original Washington Privacy Act proposals, which they themselves were modeled very closely on GDPR. So what's interesting is that those US states and those new US laws coming on stream are actually going more GDPR-like, not less, and not necessarily doing a copycat of California. So turning now to the UK, where's that put the UK? I think it's really interesting that we have the UK in this position now, which was very closely aligned to the GDPR, because obviously originally was in the EU. Then you have Brexit, then you have equivalence, really. You then obtain adequacy. And then we now have this divergence or this potential confusion being created with rules that will be different and that will be leaning towards, US, but in particular, maybe leaning towards more the California approach as to what's going on with these other US states. So from a business point of view, if you're a company, and I know this because, when we're advising clients, obviously one of the first things they want to have, if possible, is pragmatic, sensible, common sense approaches to these things. And what they don't want is lots of different laws in different places. So I think even though, as I say, the UK government approach has been, this will be good for the UK economy, this will be good for UK business, because it's going to be cutting all of this red tape as they see it. I think there's a genuine concern about this divergence. And as you say, I think there could be a risk in terms of leaving the UK in a strange way, more isolated as a result of some of these initiatives, which it thinks, or some of the government spokespeople seem to be thinking, will increase its ability to be a global player. So I do think it remains to be seen in a year or two if the legislation passes, where that will leave the UK. And I think things like the CVPR initiatives and things of that nature, definitely they have some potential. But again, coming back to what companies want, what businesses want, is they want some degree of consistency. That's what we're hearing repeatedly. So I think it's going to be really interesting to see how it all plays out.
And indeed, we'll be following that closely. But I wanted to go back to Gabriela now, because in the GDPR, there are two coexisting narratives. The first one is that the EU has set the golden standard in terms of data protection worldwide. And the second one is that the GDPR is enforcement is going rather slowly. We see especially civil society groups saying that expectations are yet to be fulfilled, and even regulators admit that it is still to reach its full potential. So how are enforcement trends shaping the way the GDPR is perceived globally?
Thank you so much, Luca, for asking this. This is one of the topics that I've delved a lot into. And frankly, I would say everyone has a degree of being right in this debate. But let me point out to the fact that there are a number of very significant GDPR enforcement decisions out there. So I think it's unfair to say that enforcement of the GDPR is very weak or absent, because it is not. There has been a very slow start. That is true. Now, there's also a difference between many small cases and fewer big cases. But we have, from each of those two categories, we have a lot of enforcement going on. Let me give you just one example. Actually, today, when we registered this podcast, my colleagues from the Future of Privacy Forum Brussels office have launched a case law report that is looking at one of the new provisions of the GDPR, a more mystical provision, because it's the one that has a data protection by design and by default obligation. So in Article 25 of the GDPR, which is an obligation that was introduced with the GDPR. It was not part of the former directive. And they have identified about 160 cases that specifically enforce Article 25, finding non-compliance and breaches of that provision, and have analyzed and summarized about 90 of them. And they have found some very meaningful enforcement of a concept that's new, right? Privacy by design, if we want to call it that way. Last year, we did a very similar exercise on a very important topic, automated decision-making, and how the GDPR is being applied to automated decision-making, and in particular, how Article 22 of the GDPR has been applied in case law. And we've identified a myriad of cases that look at some of the most complex processing operations that are taking place today, that involve algorithms, algorithmic decision-making, that are done by gig economy companies across Europe, for example, or facial recognition systems that are being proposed to monitor entrance and attendance in schools, or to monitor supermarkets. All of these cases have actually been subject to GDPR enforcement. And this is, not to mention some of the most, some of the cases that have gained most attention from the public and from the media, like the cases against Meta that involve data transfers or other issues, or cases against Amazon as well. So, in short, enforcement of the GDPR is actually happening. Now, there is also a separate debate on whether how it's happening is at its most efficient. And this has been a debate in Brussels for a couple of years now. This is also where the civil society has a loud voice, I would say. Looking at the current governance system with the one-stop shop and whether this is, let's say, the most efficient of what could be in the GDPR. Now, that's a different story indeed.
Thanks, Gabriela. Going back to you, Rafi, before you mention about the risk of the UK losing its EU data adequacy decision, just how concrete do you think this scenario is, and what would be the implications of an eventual loss of this status?
Yeah, I think it's. I'd kind of probably answer that in the round, in the sense of, I think there is so much going on right now, and obviously there's. I would just also mention the sort of the boom in AI and all of the under the spotlight attention that anything AI related is going along. And again, just to mention that. One of the amendments in the DPDI2 is to look at automated decision making and potential impact or relaxation in relation to AI. That's going to be one. Again, that's one small amendment that's proposed, but I think it could have quite an interesting impact in terms of how closely the final law is looked at and whether those in the EU would think that's not a minor change, that's a big change, or that's an important change. We don't like that. So again, on the automated decision making, just very briefly, there's a tweak proposed which basically says that there'll be a relaxation of the restriction where you have a decision made without human involvement, and the language there is the restriction will only effectively be kicking in if it's a significant decision made without meaningful human involvement, and then there's some other wording in there related to how you can have to be informed by that and some other checks and balances. But I think some changes on legit interest, some changes on cookies, some changes on profiling, changes on automated decision making, and so on. I think some of those changes, even though each one of those changes on their own might not be regarded as a huge change, and I know some of the UK government team that have worked on this quite hard, they've been quite careful to try and take consultations from the UK ICO and from other stakeholders to try and make sure that the changes don't deviate too much from GDPR. So they believe and they feel fairly confident that it isn't such a big leap from GDPR that adequacy is going to be terminated. But I do think if you actually look at the collective impact of some of these different elements, there is a risk there. So I just kind of sum it at that. The one thing I would say in the big picture is, I come back to that point we spoke about a little bit earlier on, which is how does that sit with all the other things that are going on with the global CDPR, with the Biden executive order and the framework, et cetera, et cetera. And I think again, coming back to what with all this change, what should businesses be doing? Well, how should businesses be looking at it? I think the best way to sum it up, I would say, if you're a business that has dealings with the UK, if you're a business that's global and you have dealings with the UK and the EU, or indeed you're a genuine multinational enterprise, I still think a good starting point is to look to update and revise all your policies, procedures, contracts, and so on with a mind for GDPR compliance, even if some other countries are becoming a bit more relaxed or they're having some variation on that. That would still mean that you need to revise things for the UK, for example, if the law does indeed change. And that still means you need to be mindful of other laws, depending on where you may be. And obviously, if you're operating in the States, the state laws. But I do think, if I rephrase that, I don't think GDPR is going to go anywhere or disappear, because I do think we've still got this global trend. So I think the UK, in deviating from GDPR to a degree, the more it does that, I think it's going to be going out a little bit on a limb, and businesses don't want that. Businesses are definitely saying they want consistency. So if I had to sort of be a betting person, I had to try to take a view on it, I think the detail of what's being changed in the DPDI2 and how that's finally going to be left in terms of what's on the statute book, when the EU come to look at that, I think the combined total impact of all those small changes, it'll be very interesting to see how the EU view that. And I think that will be the decision maker on whether there's a real push on the EU side to seriously consider removing adequacy. I think that's going to be, we can't judge that right now. It's going to be interesting to see.
And Gabriela, before you mention this landmark case with Meta and international data transfers, do you think this has the potential to change the tone of the discussion?
Frankly, I don't think it will change the tone significantly. I mean, it is a very significant case, but it's not the first very significant case, right? It's just a case that has been going on for a very, very long time, and that will soon have a resolution as far as we are aware of the timeline from the EDPB and the Irish DPC. So I wouldn't think that it will significantly change the landscape, because also I think that, you know, enforcement is there. I mean, enforcement of the GDPR is out there. This will be, let's say, the latest big case, and a case that has garnered so much attention because it has been going on for a very long time.
My quick thoughts on the sort of ripple effect on that case is quite interesting in terms of, I totally agree with Gabriela that it's one of those, but there are others. There have been other very major decisions, and there's a lot currently in the pipeline in terms of other decisions. And I do think, in a way, I think some businesses who are hoping to have the DPF come along as a kind of rescue package in a way, and they're hoping that the EU will confirm adequacy for the rebooted Privacy Shield. I think the note of caution, which is always there in the background, is again if you see any of the commentary from Max Schrems and some other commentators who obviously are watching it extremely closely, they are saying that even if we do have a DPF come along, which is going to be heavily relied on by, say US companies, that in itself may well only last a year or two before we have another court of justice challenge and a possible shutdown again. So I do think there isn't going to be one kind of single event that dramatically stabilizes the landscape, or indeed throws it up and down. I think it's going to be a constantly evolving one. And I think that would be my sort of take on that particular decision.
Gabriela, any concluding remarks on this?
Just two thoughts to wrap this up. The first one is that, just as Rafi pointed out, the GDPR has had such an incredible effect around the world in terms of inspiring jurisdictions to adopt similar laws. We are seeing laws being adopted as recently as this month in Nigeria, for example, which is a very, very populous country, more than 200 million people that now have data protection rights. Vietnam has adopted its decree in the past month or so. It's really happening all around the world. So definitely an important trend to be mindful of. And the second thought is that I think we'll have to think more and more often about the intersection of AI and data protection law, automated decision making and data protection law, and figure out how this law is relevant, in fact, for some of the uses of this new technology and how it's being built.
And sorry, just a very good points from Gabriela. At one point, just to mention also, is I totally echo the point on the AI. We obviously saw brought to light the potential tensions with GDPR compliance generally, with the Italian Garante's action with ChatGPT. And obviously there's been some back and forth between OpenAI and the regulators, but there are other regulators looking at that as well. And I think there's no question that that's going to be another factor that I would say reinforces the need for businesses, depending on what they're doing with their technology and what they're doing with their processing. And obviously AI is an obvious area to consider how the GDPR affects them or not. Again, I think going forward, it's going to be yet another area where I think GDPR is going to become super topical.
Rafi Azim-Khan is Head of Data Privacy at Pillsbury Law. Gabriela Zanfir-Fortuna is Vice President for Global Privacy at the Future of Privacy Forum. Thank you both. That's all we got time for this week. Don't forget to sign up to our free Tech Brief newsletter to stay on top of tech news and digital policy developments in the EU and beyond. Also, don't forget to subscribe to this podcast published on Apple Podcasts, Spotify, Stitcher, and Amazon Music. This episode was produced with the technical help of Avi Chiori. I'm your Luca Bertuzzi, and thank you for listening.